right, moving down the line. Yes, we are on to Brian Bennett, instructor at the South Carolina Criminal Justice Academy, our law enforcement guy of the day, huh? Thank you so much for being here, Brian.
Thank you. First off, let me say, Madam Chairwoman, members of the committee, thank you for this opportunity to speak with you. It's an honor for me to be in front of you. I'm going to keep you engaged for the time that I have you. You're going to be on the edge of your seat, and I'm going to give you a practical a rundown of the things that law enforcement officers face. I may be able to offer you some solutions, because I'm not a big fan of complaining about something without offering some type of resolve to it. And some other considerations that you might have in the days ahead. First of all, for those of you that don't know me, my name is Brian Bennett. I have served as a law enforcement officer on the street for 10 years. As of the last, almost coming up on 8 years, I've been an instructor at the South Carolina Criminal Justice Academy, specializing in criminal domestic violence and the vulnerable adult and elder abuse in South Carolina. I'm a 1997 graduate of the University of South Carolina's College of Criminal Justice, as it existed at the time, and started my law enforcement career in 1998. And also I turned 41 this month. So my baby face sometimes causes me some problems, sometimes the credibility, not that you would, but I wanted to qualify myself as having at least some years of experience in this area. Additionally, as part of my duties to let you know what I do, I not only teach at the academy, but I'm also, as all the instructors there are, assigned the duties of addressing problems, researching the problems, writing the curriculum, and having that curriculum vetted through legal approvals. So things that we promote at the academy have gone through a legal review. They've been researched, and each of the instructors, including myself, are the ones responsible for developing the curriculum. So basically, I tell people I've written about 10 master's degrees because all 10 of my classes, both basic and advanced, are in manuals about that thick. Which, by the way, you're probably looking at this. I've prepared this for you. I'm going to give this to you when I leave here today. What you're going to have in here is there are 4 copies of a DVD. It's 2 hours long. However, what I'm asking you to do collectively as a committee is to watch that DVD. That DVD is a 2-hour video produced by the National Strangulation Training Institute and the Family Justice Center of California. It will give you a complete overview of the dangers of strangulation, not just in domestic violence, but focused on domestic violence. It's going to give it to you from the initial aspects of anatomy. They're going to have 2 well-seasoned, nationally recognized prosecutors who are going to give you their perspective as a prosecutor and why that's important to know or focus on the strangulation issue. And they're also going to show you and demonstrate for you with forensic pathologists and medical professionals who have researched this to the ends. Again, I'm hoping collectively you sit down as a committee and watch this. I think it will blow your mind, and I'm telling you, you will see things in there and hear things in there that you have never thought of before in the realm of strangulation. Also in this is also an Attorney General's opinion that I'm going to reference. And everything in here has been highlighted for you. It's been tabbed, cataloged. Strangulation research, strangulation laws by state are in here. A strangulation investigation manual is in here, which includes all their research, national research. I also have for you in here the Department of Social Services Domestic Violence State Report for 2012 and 2013, which talks about the batterer intervention programs, their rates, and all their graphs and charts and all that kind of stuff to kind of compartmentalize it. And then a listing of some of the previously introduced criminal domestic violence bills from back in currently through 2011. So this will be made available for you in the committee for your review. All right. So additionally, real quick, I'm also serve on the state's Vulnerable Adult Fatality Review Committee and the Adult Protection Coordination Council for South Carolina as well, and that's in the realm of vulnerable adult and elder abuse. I come to you today, obviously an employee of the Academy, but I'm speaking to you as a law enforcement officer from the law enforcement perspective, and you might ask where I get my information from. I travel all over the state, and I have been traveling all over the state, teaching classes, both basic and advanced, in domestic violence investigation and prosecution. Our basic training cadets are given a very comprehensive 40-hour course in basic training on domestic violence. Not just the law, but all the behavioral science, all the psychology behind how these relationships develop, how victims think, how suspects think. They also get training on Act 141, the Victim Bill of Rights, victim services that are available, prosecution. So it's very, very comprehensive, and we carry that out in the field in advanced classes. And when I'm out in the field, I get a lot of feedback as to particular concerns. Some of it's regionally, some of it's collectively across the state. And so that's what I'm coming to you with today. Everything that I do is heavily researched. I don't go in anything without researching things, so be prepared for some stuff. I hope not to ruffle any feathers, but to be honest, I might have to step on some toes today. In that regard, we as law enforcement officers are limited to what the parameters of the law. I mean, that's really what guides us. I mean, prosecutors have their guidelines, defense attorneys, the judiciary. We likewise in law enforcement have certain guidelines and parameters that we have to follow that dictate what we can and cannot do. So in many cases, we rely on statute. So I need you to go ahead and put that out there. All CDVs have the potential to be a homicide. That's one thing we tell our cadets. Every CDV call you go to has the potential to be a homicide because research has borne out that the longer these relationships go on, it will lead to someone leaving the relationship or being killed. Now, immediately, a lot of our minds go to the victim. But I want you to expand just a little bit on that. Our law enforcement officers are killed. Okay? Not only that, all those around that family member can be killed. Case in point, the 5 children that were killed in Lexington County. I have not seen that case. I have only seen what was reported on the news, but I can tell you right now, with what I know in domestic violence, that was done as a tactic to get back at the female, to hurt her in a way, the things that she found most precious. And so it goes beyond just the initial victim. It goes to our law enforcement who endanger their lives every day dealing with these repeat offenders, and all the family members or any of our service providers who attempt to provide some help. So it's a lethality issue for all of us. The act of strangulation, particular to itself, demonstrates someone's ability to take a life, and they've made a decision that they would do that. Now, in the realm of domestic violence, what we find is that most offenders strangle. The victim's going to use the word choke, but technically, mechanically, it's strangulation. They do that to incapacitate the victim, to harm them further, or to make the point, I can kill you at any time. But in fact, when they utilize that act of strangulation, people will kind of equate the attempt. Well, there's no attempt at strangulation. You either strangle somebody or you don't. But if people look at death and strangulation down here, y'all, they were equal. Okay, that is a deadly force action, and it needs to be treated as such. Someone who's demonstrated the ability and has gone to the point of putting their hands or something around someone's neck to restrict their breathing or their blood flow has demonstrated that they have gotten to a point to kill someone. So these are the most dangerous individuals that you're going to deal with, someone who's gone to that act, that level. This might surprise you. The study from California, and they're the only state that I know that's done a comprehensive study on this, has shown clinical evidence and empirically through research that an individual who survives one strangulation event, that there is a 700% increase of them being strangled again. And there is an 800% increase that they will be killed later. Now, it may not always be through strangulation. Again, strangulation tells you that the mindset is at the point they will kill somebody. Now, what means they kill somebody can change, but there's an 800% increase after that first attempt. Along with that, it's also been correlated that 80% of law enforcement critical incidents, that namely being where there's been lethal force used, either by the officer or on the officer, 80% of those involve someone with a history of domestic violence. So think about that for a minute. Strangulation has cumulative effect. I wish I could get into all the medical stuff and what you can see, and that sort of thing, but I will say this. Every time that act occurs and it goes to the point of unconsciousness, or even not unconsciousness, it has a cumulative effect. Brain cells are dying, And again, it is empirically and medically researched that as time goes on, these repeated strangulations will degrade the brain. That people's cognitive abilities, their decision-making abilities, sometimes their ability to walk, talk, to maintain a certain healthy lifestyle will be diminished over time. It's just a simple fact. When brain cells die, we stop doing things. Okay. Just recently, here in Beaufort, September 11th, last week, we have an offender who has not been found. We have a victim who's dead, and it was checked back in the records that there were some prior instances of strangulation. And I think that kind of backs up what all the research says that we have, both collectively and across the country. Another thing that might pique your interest is the Journal of Emergency Medicine has done no less than 6 studies. That's what I can find. I think there's more, but no less than 6 studies on how strangulation is tied to domestic violence. That says something too. So where does that bring us? I believe that this state needs a strangulation statute for a couple of reasons. One is laws need to have a teeth. Okay? So with the existing laws that we do have, there's wording in some laws that say may and some that say must. Certain actions by law enforcement, certain actions by those involved. When there's a may in there, it allows a lot of people to have a lot of latitude and a lot of things not addressed. When it has a must in the statute, then that says exactly what it is. It's a must. There is no choice. There's no discretion involved. It says it must be done. So as we look at the laws that we do have, in any future laws, let's look at the type of wording that we use, may versus must. 37 states, as of January of this year, have a strangulation statute. Those are listed for you in here. Not just the state and their statute number, but what their statute actually says, so that you have some models that you may look at. And again, a lot of these statutes use specific wording that not only define what strangulation and suffocation. Suffocation is a different act that can have the same result. It's a different mechanism. But it defines what strangulation and suffocation is, and it is backed up by common terminology that is used within the medical profession and kind of the vernacular of the environment that we're in. Miss Hunter, Skilled Cobb Hunter, back in 2011 actually introduced a bill, H 3208, that attempted to define and criminalize an act of strangulation as an immediate felony, as it should be, as it should be. I hate to, I'm sorry to say this, but a strangulation event under certain parameters and with supporting evidence could actually go to an attempted murder charge. And that's what I would go for. But at minimum, we should be charging criminal domestic violence of a high and aggravated nature. Minimum. But what we see sometimes is that there's too much latitude there, and those strangulation events, even with all the training that we give, are not seen as being a serious matter, and so it's kept in the realm of a misdemeanor CDV first or misdemeanor assault when it should have been a felony level charge. I mean, we're talking about killing somebody. I mean, it's why we're here. People are dying, and so it's something we need to consider. It gives prosecutors and law enforcement something more to work with when we don't have maybe something that fits the specific issues of CDV or a specific other statute. It gives us something else. It gives us some more water out of the well that we can pull from to address that issue. Recently, I was made aware of a case where a young lady in the upstate had a history of domestic violence. From what I understand, her offender had been charged. He was out on bond. There was an order of protection. Like a year later, he ends up coming up to the hospital that she works at on the, I think, 8th floor of the hospital and strangles her in front of all her coworkers, in front of security staff. Law enforcement officers get on the scene, and she has some very, very significant injuries as a result of the struggle. The time that he had to do these things before there was law enforcement intervention. And from what my understanding is, it was brought forth to the prosecution. that this needed to be charged as a strangulation, even though with medical professionals, medical treatment that was done with all these witnesses, and prosecution declined to take it up that high. It was charged as a CDV second because of his prior CDV first conviction. That's a travesty. Like I said, when someone does that private act of strangulation in that home, they've demonstrated, but now they've decided to do it in public with law enforcement officers standing around, security personnel and employees. I just think that just made me feel horrible. So I want you to consider potentially a strangulation bill, something specifically for that, because it's going to help in the realm of domestic violence, but certainly in other areas as well. My second main point is the issue of case dismissals. One of the most frustrating things for law enforcement officers is to have our cases dismissed. Now, let me say this. Law enforcement officers understand that prosecutors have prosecutorial discretion. They are also fully aware of the fact that judges have judicial discretion as well. So I want to put that out there. They know that exists. It needs to exist. There's reasons for it, but let's look at some things. Law enforcement officers want due process. We want due process. I mean, that's something afforded to us in the Constitution. It's one of the tenets of what our government has been built on, so we want that. So we're not asking for any changes on what the powers of a judge. I mean, we can't take away that judicial discretion. We can't take away that prosecutorial discretion. But this is the problem. We as law enforcement officers sometimes don't even get a chance to open our mouth for a prosecution. Okay. Now, don't get me wrong. There are some courts in South Carolina where the judges are very receptive. We know that victims do not show up to trial generally because of fear. There are plenty of cases out there, plenty of physical evidence that we can collect that does not require the victim's testimony. But some of our judiciary have the attitude, well, if it's not worth the victim's time, it's not worth the court's time, I'm dismissing this case. And the law enforcement officer who's put their life on the line, who's collected the physical evidence that could stand in place of a victim's testimony, doesn't get the chance to even put anything on the record or make the statement, we are ready to prosecute. Matter of fact, I've had officers call me and say, I actually respectfully requested the judge to reconsider their dismissal based on the fact that I had evidence. I had things of a physical nature, physical evidence, that I wanted to present. And the judge looked at me and said, officer, if you open your mouth again, I'm going to fine you in contempt. Now, most of our cases are tried at municipal level, summary court. Our summary court judges do not have to have a law degree. Some of our officers that are going into the court have more legal knowledge than some of the judges they're trying cases in front of. So what is it that supports, what is it that exists constitutionally or statutorily that supports the fact that officers should at least have the opportunity to present this to the court when there's sufficient evidence, okay? When there's sufficient evidence. In here is the Attorney General's opinion from 1997, where the Sheriff's Association for South Carolina asked for a legal opinion. Is there any reason why the courts or the officers cannot prosecute a case without a victim? And what the Attorney General wrote at the time was, and it's highlighted in here for you, is that there is no constitutional or statutory regulation that prohibits the prosecution of a case without the victim. Matter of fact, we do it in murder trials all the time. They provide that legal background in here. The additional part of it, because as law enforcement officers, we want to promote due process, the Sixth Amendment of the Constitution demands that the defense have a right to confront and cross-examine their their accuser. And sometimes cases are dismissed because, well, the victim's not there, there's no person to cross-examine. Well, in this opinion, it also supports the fact that if that law enforcement officer is an affiant on that warrant, or an affiant on that ticket, the one that actually made the charge, was actually there to collect evidence, to take statements from people, that the Sixth Amendment confrontation right by the defense is not infringed as long as that law enforcement officer can stand in that court and field questions from the defense. The Sixth Amendment right to confrontation has not been infringed. So we're preserving judicial discretion. We're preserving the defendant's right to Sixth Amendment due process and confrontation. We just need to make things such that a law enforcement officer who's put their life on the line can stand up in front of the court and at least put on the record, we're ready to go. Now that brings up another question. A lot of law enforcement officers don't want to get into an argument with a judge, and I agree. I'm not going to get into an argument with a judge. I'm not going to get into a power issue. So some officers are afraid to have that conversation. Your Honor, we respectfully request you consider your position. So another bill that Ms. Gilda Cobb Hunter had presented back in 2011, H 3207, basically was worded such as this, that prior to a judicial dismissal, the officer must be asked on the record if they're ready to prosecute the case. They need to have the opportunity to make that statement, and that at that point, if the judicial dismissal is done, there needs to be given a written record of why it was dismissed. Just give the officer an opportunity. A.J. Corzin and Dana Tate from the Beaufort County Sheriff's Office, Lonnie Wells and Marcus Stiles from Moncks Corner PD, Deputy William Howell from Orangeburg County, Deputy Roger Rice from Lawrence County, Investigator Joe Sapanizo from Greenville County, Lieutenant Randy Gerald from Horry County, and Deputy William Crawley, Chesterfield County, were all killed in South Carolina responding to calls for domestic violence. I think we owe it to our victims, and we owe it to our officers who put their lives on the line every day to investigate and prosecute these cases, to at least put something into the record that we're ready to go and prosecute with things that don't necessarily require the victim's testimony. And that's why the Academy, we promote evidence-based prosecutions, not testimony-based, because then the victim doesn't show up. So we are real heavy on evidence-based prosecutions. And along with that, Criminal Rules of Evidence 801D2 allows for the officer to talk about the admissions by the party opponent, what the defendant told me. I may not be able to say, because of hearsay, what the victim said, but I can certainly bring up what the offender said. The solicitor that we had today made talk of their body-worn cameras, and those are great. Don't get me wrong. Those are fantastic. Not every jurisdiction has them. So we obviously tell officers to be prepared to not have that. But this is one thing I'm going to point out, the body-worn cameras. That victim, when they're videotaped, when they're taped, that's still considered testimonial evidence in the court. That is still evidence that has to be, have the right for the defense to confront and cross-examine. So as good as those things are, there's going to be some challenges in the court on whether the portion of the tape where the victim was interviewed could actually be used if the victim's not there. It's better to have it and not need it than need it and not have it. But that's going to be a problem, is what can we actually use the victim's portion of what they said if they're not in court. And the last couple issues which have been mentioned previously are the bond hearings. What we hear from out in the field is that bond hearings and the bond conditions really don't have teeth. Let me give it to you in practical terms as a law enforcement officer. I worked the road for 10 years, dealt with it every day. I was a training officer down at the academy. We would get a call, go to a house because the victim's scared to death because someone's outside their house or around, and they knew that the bond condition was the person could not be there. There's nothing I can do. When I say nothing I can do, I mean nothing at the moment I can do. I can write a report. I can take an evidence of the violation of bond back through the courts, but then I have to go through a judicial process and a hearing, which takes a lot of time. An order of protection, although it is a piece of paper, gives me as a law enforcement officer to act immediately. With a bond condition, I basically look at the bond offender and go, hey, look, we know you're out on bond. My advice is that you get out of here because you're subject to being arrested or going back to jail, but not now. So bonds have to have a little bit more teeth. Now, one way to possibly resolve that, and I'm not meaning to step on any toes here, but we give the family court jurisdiction to first court of jurisdiction for an order of protection. Emergency orders of protection done through the magistrate courts. We exclude municipal judges. Municipal judges, however, are some of the same judges that set bond. What about allowing a victim, if they wish, to attend the bond and request an order of protection there? Because when you ask the victim to leave and go to a shelter, well, over the next 2, 3, 4, 5 days, maybe a couple of weeks, they're having to move, go to this place, this place, this place, this place, this place, exposing themselves even more. they're exposed to that danger that they were trying to get away from in the first place. Perhaps there's a mechanism in place where we can empower our municipal judges who set bond, or any of the judges that set bond, to issue an emergency order of protection right there, so that I can immediately enforce it as soon as possible if the next day that offender decides to violate the bond. I've got some teeth to it then. But as it is now, it just takes incredibly too long for me to follow up on bond revocations as a law enforcement officer. Every time that victim has to travel outside that shelter, even at the shelter, they're in danger. And again, we're trying to keep people from dying. Some other possible fixes are a mandatory 48-hour hold. I'm not sure how you feel about that, but that certainly would give, if we didn't have a provision in place where we did an order of protection there at the bond hearing, it would certainly allow a little more latitude for that victim to get some things in process. Because I don't know about y'all, but around the state, bond hearings occur at different times. I've had some agencies call me and say, I just locked up somebody, they're out in 2 hours. You know, how much time does that actually give a victim to get anything together? So maybe a mandatory hold on CDV charges. But we got to give some bonds some teeth. And the last thing I want to mention, and then I'll be open to any questions that you have, is the battery intervention programs in PTI. I believe, if I'm not mistaken, that Bakari Sellers, Honorable Sellers, had introduced some legislation into the degree of battery intervention programs. We have battery intervention programs already in place. Department of Social Services handle those. And it's handled through some of our, obviously, shelter services, stuff like that, too. So those already exist. But the point of it is, those things should only be used once. You know, when I was growing up, I didn't get any trouble with the law or anything like that, but I knew very well from some friends of mine, when you got in trouble, you got that one PTI chance as your wake-up call, and it was done. It's burned. But I haven't found that to be true. I've got officers and agencies that call me all the time saying, we know that this offender has been through the battery intervention treatment program 2, 3, 4 different times, sometimes within the same jurisdiction, sometimes in multiple jurisdictions at the same time. There's a place for it, don't get me wrong. But once you burn it once, that should be it. That was your wake-up call. Same thing with PTI. I can't tell you how many of my own offenders were pled down to something less than criminal domestic violence, or they pled guilty to domestic violence, were offered PTI as that chance to get it right and not do it again. But then down the road, oh, I found out they're in another PTI program, and they're in another PTI program. And that's problematic. We can't allow people to keep burning the same bridge over and over again and expecting us to give them a pass. That's like them thumbing their nose at the court saying, well, I appreciate your willingness to help me out. I'm going to take it, but then I'm going to manipulate it and use it for my benefit to keep re-victimizing, to have a way out, I guess you could say. So something to consider there as well. 2 points I want to mention about the gentleman from USC's School of Law. He mentioned the spousal sexual battery. I tend to agree with him on that. Sexual assault is sexual assault is sexual assault. So I think it all needs this, whether you're a spouse or not a spouse, I think it all needs to remain in those high-level felony areas. This might surprise you. 40 to 70% of all CDV calls incorporate sexual violence. Tell my cadets that, and it blows their mind. They're like, 40 to 70% of CDV calls I go on, there's some type of sexual violence going on. I'm like, yeah, let's think about the control factor. That's like one of the most degrading forms of control, to control someone sexually. Yeah, we have the physical violence and the psychological, but when that sexual component becomes there, it becomes that much more powerful. And one thing that I'm hoping to improve in our law enforcement circle is we are continually doing law enforcement education. Matter of fact, every year we produce a 4-hour CDV training video for our law enforcement officers in South Carolina, all 17,000 of them. And we're always promoting, don't always look at things just in the realm of CDV. It might be a CDV incident, but if there's a better criminal charge that will address the facts and circumstances of that issue, explore it. Don't just slap a CDV arrest on there as a Band-Aid for a much larger issue. And that's really what CDV arrests are. They're a Band-Aid for a much larger issue. It's a temporary measure. But what we have found, and not so much here in South Carolina, let me correct myself, but in North Carolina where I've done research, what they have found is that when they add additional charges, as exist in statute, which they can pick from, specific to the incident and facts, what they have found is that when they add additional charges such as stalking, harassment, obstruction of justice, witness tampering, unlawful communication, unlawful use of the telephone, they have found that their conviction rates go from 33% to 93% in domestic violence cases. Why? Because there's a plea bargain that happens. When you've got a defendant who comes to court and only faced with a CDV, you put it down to simple assault. Get PTI and make the record clean so they can do CDV again and go through it again and pled down. But when you come into that court and you've got felony stalking hanging over your head because on that jailhouse telephone call you told the victim, I'm coming to you, I'm going to kill you. I've got $12,000 and I can make you disappear. I've got these recordings from the jail. Witness tampering. Hey, tell the prosecutor that we're made up. I'm the breadwinner. We've got our kids we got to keep this thing together. Obstruction of justice, witness tampering. When those come to the court, sometimes our defense attorneys come in there, or especially in these other states, and go, can we make a deal here? We'll plead guilty to the CDV high and aggravated if you drop the kidnapping, if you drop the stalking. It gives us something to work with. And again, I'm not a big proponent of adding a bunch of new statutes. If that's what fits, okay. But if we can take some of the statutes that we have and tweak them just a little bit, change words from may to must, and certain things as statutes already exist, just tweaking them a little bit, there's some quite significant changes I think we can make in the law enforcement side of things, and collectively as a whole. I'm in full support of the fact that this is a comprehensive direction we have to go from all of these parties. That's all I have.
Thank you so much. I've got a constituent who's a retired police chief from Massachusetts who shared with me some of the reforms Massachusetts made, and one of them is actually, and forgive my unfamiliar use of terminology, but the officer of the day or the sergeant on the desk or whoever's in charge actually has the ability there to issue a 24 or 48-hour order of protection, to give that piece of paper to the victim so that law enforcement can act a little bit further if that person is out on bond and they have not gotten whatever they need to do. Something you'd be interested in? Have some problems?
I think so. From what I've heard, the northeast of the United States are the ones who have had that in place for quite a while, and it seems to be effective for them. I don't know all the details of it, to be quite frank with you, but what I can say is we have a lot of law enforcement officers that come down here from the northeast who either work there or retired, and they're coming back through the academy, and that's one of the things that they always bring up is it really takes that much to get an order of protection here in South Carolina. We can get it done in like 2 hours at the desk at the police department. And I'm like, I don't know what legislative mechanisms are in place or laws that allow that, but they have it.
He said that was the most effective tool that they had to get the victim out of danger. When I picked his brain,
I can certainly research that for you.
I'd be interested. I thought it was kind of interesting that he thought that was the most effective tool they had available to them to be able to act quickly. Are there any other questions of the committee? I'm sorry, Representative Talon.
Thank you, Ryan. You've done a great job. Thank you very much. Thank you for your service. Question: do you do training, CDV training for the magistrates?
No, sir.
Does anybody do CDV training for the magistrates?
They do, as far as I know. Let me just clarify this. Under South Carolina statute, the academy is specifically mandated to train law enforcement. There is, and if I'm not mistaken, it's through the Bar Association. There is a new magistrate training that does take place. When it takes place, I'm not sure, but they generally utilize some of the classrooms at the academy. But there is a body of lawyers who do training for the magistrates, for the judiciary. But to the content or the extent of what domestic violence training, I'm not aware. Now, what I can say is this. In the CDV statute itself, it says that judges will get criminal domestic violence training, but how much and how long is set by our South Carolina Supreme Court.
Okay.
And
Ms. Cobb Hunter just said that the bar was the one that did that the courts do the training. Excuse
But
me.
again, the content and the duration is set by the Chief Justice.
Is there, and I believe it is now in statute, that if a person is brought in and charged with CBD, like it does before the magistrate can hold him for 24 hours before he sets bond, to at least give the person or the victim a chance to get out of the house or to get their stuff together, or at least a little bit of protection. Is that correct?
Yes, but I rarely see that happen. Quite frankly, I rarely see that happen, and I'm not sure if that has to do with budget and personnel matters of staffing of the jail, jail capacity. I can put it to you in practical terms, my own experience, that never happened in any of my CDB cases. They were held for 24 hours.
Did you ever ask for them to be
Yes,
held?
matter of fact, under some of the laws, I think it's Title 22, where it talks about bonds. A law enforcement officer, along with the charging document, the incident report, the law enforcement officer has the ability to give the judge any additional information for that judge to set an appropriate bond. Every one of my CDV cases, I always wrote nearly a paragraph of other information that I knew about that offender for that judge to set a higher bond maybe than what they wanted to, but it's my suggestion. They don't have to follow it, but I know that law enforcement officers do provide additional information to the judges at bond in many
But at
cases.
least to hold them for the 24 hours. Have you ever asked for
Yes, directly.
an
I have
offender
that.
to hold them and they've not done it?
Yes, sir.
That's a problem. Thank you.
Ms. Copiner.
Thank you, Madam Chair. And Brian, thank you so much for your testimony before this committee today. It has been very, very helpful from my perspective. And you talked about the strangulation bill that I introduced, and you testified before that criminal law subcommittee.
Yes, ma'am.
And looking at the information from Dr. Bush this morning, I appreciate you saying that sometimes people say choking and it's really strangulation. Do you recall the subcommittee hearing where you testified and some of the arguments that were made about why that bill was not a good idea? And if you do, how are we to respond to those concerns that were raised that day?
If I remember correctly about that, I believe that was about a year and a half, 2 years ago, something that area. If I remember correctly, the terminology basically was one that they thought was, I guess, too medical in nature, I guess you could say. Because some of that, if I recall correctly, had to do with not just the definition of the strangulation or the suffocation, but the signs and symptoms of, and I could do a whole 8-hour training class on the signs and symptoms from the clinical and sociological. But I think that was part of it. It wasn't so much that people didn't want it. It was maybe just the wording that was in there might have been
Right.
too
And I guess
complicated, maybe.
yeah, and I'm going to pose to you the same question that I have presented to the coalition, and that is whether or not you would be interested, from your perspective as both an officer on the street as well as a training officer, if you would be willing to take a look at existing statutes. I know, and you've talked about some of the things that you think should be tweaked, but I believe this committee could benefit from having your review of current statute and with the eye toward prosecution, what your officers face in that courtroom, and some of the things that have been reported to you as problematic that we might look at addressing. That would be helpful. Would you be willing to do that?
Absolutely. Again, with and for this being research, I've got about 10 more stacks of research that cover those issues. I would be more than happy to look at the specific wording in the other states. And again, I gave you some of those references in here as well. The wording of those other state statutes are in here, but I'll be more than happy to look at that and maybe craft or suggest some specific wording that may be appropriate for South Carolina.
That would be helpful. And if you would also speak to the issue of training. I am always interested in ongoing training, and I know this is a price tag attached to this, But is it accurate that our officers go through that first initial training at the academy? They get what you all have as far as DV curriculum, and there is some ongoing training required every year. But is that annual training, does that include requirements on CDV?
Yes. Now, as far as the basic training at the academy, what we kind of look at is bring everybody up to a standard, and that's why I said our training is very comprehensive. It's not just the law; it's behavioral science, it's prosecution, it's victim services. So when these cadets come out of the academy, they are all on the same page. They're all on the same page as far as their knowledge of good interview techniques, warrants versus uniform traffic tickets, and I mean the whole gamut. Now, what happens after they leave the academy, in many cases, is left up to the agency.
That's what concerns me, and if you would, when you give us your recommendations, would you give some thought to how we might weave together existing entities, for example, ETV, and in small communities where it might be cost prohibitive for an officer to leave to come to Columbia to the academy, it may be possible for us to do some of this stuff online. I just see a gap there as far as ongoing training.
Well, we actually have that in place already.
Oh, very good.
If you've never been out at the academy, please come out. We actually have a television studio at the academy, just like you would see at WIS-TV. The South Carolina statute says that law enforcement officers must receive 4 hours of continuing education credit specifically in the area of criminal domestic violence. That is a statutory requirement in order for a South Carolina Class 1 law enforcement officer to maintain their certification. In the statute, it doesn't mandate that the academy do that. However, we do that as a courtesy. So every year, and I just finished this year's 4-hour training video last week, which incorporated a whole hour on strangulation. We had a forensic pathologist. It's like a TV show. We go through, this year we went through companion charges that could go along with CDV. We talked about victim services. So as it exists right now, we do partner with ETV. Basically, the academy, we film the training video. We go out in the field and do interviews remotely through the state. There in the TV studio, we digitize it. We give it to ETV, and every law enforcement officer in the state, through their training officer at their agency, has a secure access where they have to go in individually, log in under their academy number, and have to view those videos and complete those videos. They can't just fast forward, complete those videos in order for it to count on their electronic training records for the academy. And if those are not done, if those hours are not kept up in that 3-year period as the law prescribes, their certification is revoked.
And you have a system in place for, it's not optional for them to
It is not
take
optional.
And that's system-wide,
Yeah.
whether I'm in small, rural, wherever, or urban,
Correct.
core, wherever.
Now, a law enforcement agency can develop their own training curriculum to serve that 4 hours, as long as that training curriculum has been approved through the academy. But as the large majority of law enforcement in South Carolina, the large majority of law enforcement rely on us to provide that 4 hours of domestic violence training per year. And in order to facilitate that at their request is how we've partnered with ETV, and it is a statewide closed login digital network of online training that they are mandated to take.
Thank you, Ms. Coppola. That was a good question and a good answer. Are there any further questions? No? Wow, thank you so much. We happily accept the notebook.
Videos and
Thank you. That's fantastic. We appreciate your service and your time as well.